Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding the proviso to section 147, which says that if the assessment of the assessee is already completed and the notice under section 148 is issued to the assessee, then in that case the assessing officer has to disclose in the reasons or to mention in the reasons that the assessee has not disclosed in the original assessment, due to which the assessing officer has to issue the notice under section 148 for again assessing the income of the assessee which has escaped. This proviso seems to be very typical. This issue has been very well taken by Ahmedabad ITAT D bench in the case of Deputy Commissioner of Income Tax versus JAYANTIBHAI S. Patel, and this case has been reported in 113 ITR Tribunal short note 68, and the date of the judgment is 5th July 2024. The facts of the case are very interesting. In the present case, the assessment of the assessee was already completed two times. First time under section 143 subsection 3 and then under section 147. The assessee has taken some loans from a company in which the assessee do have some shareholding, and when the assessing officer received information from some other sources that the assessee has taken some loans which come in the definition of deemed dividend, then he issued the notice to the assessee for reassessing the assessee under section 147 by alleging that the assessee has not disclosed this information at the time of the original assessment. That is why he is issuing the notice under section 148 to reassess that income. Now the question before the tribunal in the present case, which the assessee was challenging, that the assessee has showed unsecured loans into his balance sheet. The consolidated figure was there, and for that particular year there was no requirement of the law to disclose the bifurcation of those loans either in the return of income or in the balance sheet, and even for that year it was not the requirement of the return of income that the deemed dividend is to be shown. So whether in the case when there is no requirement on the part of the assessee by any law to disclose any information in the return of income or balance sheet, or in a case where the assessing officer has not made any inquiry during the assessment proceedings with the assessee to give the information, then in that case whether it can be said that there is a failure on the part of the assessee not to disclose something. For this, the tribunal said that in the present case there was no requirement of law to disclose the bifurcation of the loans in the balance sheet, to disclose the dividend or the loans into the ITR by giving their bifurcation party wise, and there was no evidence on the record that the assessing officer has called this information from the assessee and the assessee has not given this information to the assessing officer. From the reading of the case, it is very clear that it is not the assessee that he comes to the assessing officer all the times and give all the details. It is not practical possible for the assessee at the time of assessment that he by his own motion giving all the details, and no assessee will come at the time of assessment proceedings that I have also taken these loans, I have also taken given these loans, these are the creditors. The assessee has to give the information only when the assessing officer asks for this information. So in the present case, the tribunal said that the details could be furnished by the assessee only if the assessing officer made a specific query in this regard in the course of assessment. The tribunal said that it was not the case, that details were called for and not submitted by the assessee during the assessment proceedings, and the tribunal also said that in the present case any fault on the part of the assessee was not evident from the reasons recorded, and any fault on the part of the assessee can be said only when there is requirement of law to disclose something and the assessee has not disclosed. So in the present case, the revenue was not able to demonstrate that there was any failure on the part of the assessee to disclose at the time of original assessment. So the assessment proceedings were quashed on this ground. Friends, this case is very important, especially in those cases where the reassessments are done in a case where the original assessments, whether under section 143 subsection 3 or 147, has already been done. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus JAYANTIBHAI S. Patel, and this case has been reported in 113 ITR Tribunal short note 68. The matter has been decided by Ahmedabad ITAT D bench, and the date of the judgment is 5th July 2024. Thank you, friends.